Go ahead.
All right, the Court Report for the County of Oakland is now in session. The Honorable Shirley Matthews presiding.
Good morning,
Your Honor, calling people.
I did get your sentencing Ms. Posey, with regard to your client.
I did not receive a copy.
I mailed it to Mr. George.
May I have a moment to review it?
You can look at it if you want. Do you have an extra copy? I can look at an extra copy. I can give him a copy, my copy. Right. But I mailed it to Mr. George on the 15th. He probably just hasn't received it. Right. Okay. Will I get to be addressing the court today as the baby's not addressing the court?
No, Your Honor.
All right, we'd like to go first. Judge, I would like to allocute and have my client the last two people to speak, if you will. I do have corrections to the pre-sentence investigation report. Okay. I can do that first. Yeah. And then has very, very limited reading and writing ability. So I read it to him and we went over every single page. As it relates to corrections, starting on page 1, which is actually the page that starts with sheet. And moving on, there's nothing on that page that I'm addressing. Then moving to page 1, which happens to go under evaluation and plan. It's about 3 pages in, is where I'll start. Okay. Judge, on this third paragraph, it indicates that the sentence starting the defendant, the next paragraph, Judge, is the last sentence of the fourth paragraph. It indicates, it starts with the defendant further reported that he attained his high school diploma. This court knows in sitting through hearings he did not attain a high school diploma, but in fact it was a certification of completion. So I ask that that be corrected. Then moving on to page 2, under the agent's description of the offense.
court prosecutor should let me know if you object to. I think we're all familiar with the statement she's already made.
On that page, Judge, I'll come back to that, but in the second full paragraph, it indicates the last line. It starts with Agent Zoma stated he was very concerned with the parent's demeanor and events that led up to Aiden's injuries. That had to do with the Child Protective Services information that was not contained in this record. So I would just ask that that information be stricken. That wasn't part of the police report as it related to this particular case.
Now, Judge, I guess
This is at the hospital. The Protective Services came to the hospital, right?
that's correct. And again, this is the agent's description of the offense, Judge.
Again, I'm just making note that
I'm going to keep that because the Protective Services was at the hospital throughout, right?
Right, and I believe that statement was lifted from the police report.
and again, just for the record,
Okay.
that as far as that information, going to page 3, at the top line where it says the defendant was very calm during the interview, again, we would take issue with that because there was other information that showed that my client was not very calm at the hospital.
Well, when it says that he was very calm at the interview, it would matter which interview.
Exactly, and it's not clear. So I would just ask that that be stricken or made clear as to what he's referring to, because Mr. Ramore, who from
He was
the
at the hospital. He was calm at the hospital. Is that accurate?
well, I'm not clear what part, because the agent, Mr. Ramore, just apparently looked at parts of police reports and then indicated that there. It's not very clear. This court sat through, I believe it was 4 days of Walker hearing testimony, and there were numerous interviews, and I just think that that's very, it's unclear, and I don't think that it reflects,
What's your response, prosecutor? There are so many different interviews, right? There's 1 through 5, and then, right? So, and there's competency, there's so many different things. So, do you have an objection to that being stricken?
Well, I don't think it needs to be stricken. I mean, it's part of the agent's description of the offense. I mean, I'm sure counsel could take issue with the way a lot of different things are phrased, but the point is this is the agent's description of the offense taken from the police report. If she wants to make an objection for the record, that's fine, but I think the court should leave the description the way it is, because I think what's being referred to is the hospital interview, and he was calm, and that was the testimony.
Okay, I'm going to say the defendant was very calm during the interview at the hospital. All right? Unlike a lot of cases, I had, obviously in-depth contact with this case because I sat through the Walker hearing with the numerous statements made by the defendant, and it's obvious to everybody here that during many of those interviews he was not calm.
correct.
Right. But at the hospital, that was the description from the deputies. So I'm going to clarify that. The defendant was very calm during the interview at the hospital. Okay?
Later in that paragraph, Judge, the second to the last sentence, 3 lines up, it says the defendant stated Shea Cole came and picked them up and they drove to St. Joseph Hospital. That, in fact, was Robert Peck that picked them up, not Shea Cole, and that should be corrected.
Robert Peck?
Yes.
Any objection, prosecutor?
I'm just trying to look.
It's at the end of the first paragraph on page 3.
I don't have any objection to that.
Okay. The defendant stated Robert Peck came and picked them up and they drove to St. Joseph Hospital.
Further down in the next paragraph, Judge, it indicates 3 lines up, it starts with tangerine. My client indicates that, in fact, he had gotten the tangerine out of the refrigerator and Ariana fed the tangerine to Aiden.
I don't even see the word tangerine.
3 lines up. It's the first, yeah, the last paragraph.
I guess I would object
It
to-
starts with tangerine.
There's no evidence in the record of that, Your Honor. I believe that statement again was taken from the police reports, which was used for the basis.
Okay, I just found tangerine, I'm really far behind you. Okay, what did you say about it?
That my client indicated that Ariana is the one that fed the tangerine to Aiden, that he had gotten the tangerine out of the refrigerator, but she actually fed the tangerine to Aiden.
Right, my objection is that's not within the record.
What is
Defendant
this?
made...
Is this from the police report?
Yes,
What
it
does
is,
the
Your Honor.
police report
The police report indicates the defendant indicated he fed the child the tangerine.
Well, the trouble I have, Judge, is, as the court knows, police reports are not always accurate. In fact, sometimes they're downright inaccurate.
I don't have testimony to contradict it at the moment.
Well,
So-
this, I'm making that record. This will follow him, and I want it to be as complete as
Okay.
possible.
Okay, I'll add something to the defendant states that,
Thank you.
all right, Ariana.
Said that.
that.
Thank you. Then on page 4, continuing that paragraph, 3 lines down, it says, the sentence starts with deputies asked the defendant about him telling them that he called his sister at 11 o'clock p.m. My client indicates that that was 12 o'clock midnight, not 11 o'clock.
Do you see where she's referring to? She said it's 12 p.m., not 11 p.m.
No, 12 a.m.,
12 a.m. Okay,
not 11 p.m.
I don't have the police report, so I'm pretty... Is that from the police report?
And what my client is indicating was the time.
The request is to change 11 p.m. to 12 a.m.?
Yes.
That's fine, Your Honor. I don't...
Okay. Yeah, I don't have any of those reports, John. Okay.
Then the last paragraph under that section, my client takes issue with the first sentence.
Through further investigation?
Yes, and that they were both being untruthful, and then it goes on to say Ariana confessed later, and throughout that entire sentence that he indicated that that never happened.
Okay, well, this is being reported from the police report.
I understand.
He never testified to this specific.
Well, he testified at the Walker hearing,
Well, he testified
so there
at
was
Walker.
information regarding that, and there were interviews where you heard what he said.
Yeah, but
All
this is about what Ariana said, right?
the second sentence is, all I'm asking is that the court then attach a sentence saying that my client disputes this and indicates that it did not happen.
Okay, which part? Defendant disputes.
The sentence about Ariana confessed later that she had observed the defendant shaking Aiden violently back and forth where his head was snapping backwards and in other directions.
Okay, he's disputing that he shook the baby violently?
That this is what actually happened.
Okay, so what is your response?
I guess my response is the police report is where this was taken from. This is the agent's description of the offense, and it should be left the way it is.
I'll put the defendant disputes this description.
Thank you.
But it really refers to what Ariana said. This is accurate because then he said the defendant later confessed he had shaken Aiden, causing the injuries that resulted in his death.
But it's different. You're talking about violently shaking versus...
That's what Ariana said. That's not what he said.
But if the court can still attach
I
those
did,
pages.
defendant's excuses description.
Then going to page 7, under family, we'd ask that the part of indicating where his mother, Shalina Harris, that should indicate that she was deceased. And if you want to put the date of her death, I don't know if that's necessary or not.
Do you normally?
No? Okay. So that should be corrected. Under, it has shag hole.
Yeah,
That should be shake hole. Under Shaylin, it indicates that her address is in Pontiac. She no longer lives in Pontiac. She lives in Hendersonville, North Carolina. Under stepfather, his name is James with an S. His age, according to my client, is 40. And under Sean Tay Pryor, who's the half-sister, my client indicates that he thinks her age is 30. And then under the other addresses, I asked my clients if they were all listed at 674 North Perry Street, when in actuality, I think that's the address that they all have, but they don't all necessarily live at that particular address.
That's Shakehole's house, right? Is it Shakehole's house?
That's the address that they refer to. So I just want that to be clear that they don't all live at this 674 North Perry Street. Then on page 8, under the section marriage, where it has Ariana Avery, my client, it says significant other. My client indicates that that should be stricken. She's the mother of Amila, but she's not his significant other.
Okay, so she should be stricken from that portion altogether.
I would think.
Yeah, okay, I'll strike her.
Under, and then the actual written, under the comments, it's the last sentence, the defendant further stated that he and Ariana Avery remain in a relationship. He indicates that they still talk, but that's it.
Okay, so what do you want me to say?
Perhaps
I guess it's strike what your definition of relationship is.
I probably judge that last sentence should be stricken.
Do you object to that?
No.
Okay. All right, that sounds good, Mr.
Then under education, it has defendant claimed to have attained a high school diploma. That should be certification only.
Certificate. Certificate of completion. Okay.
Then under page 9, under health, under mental health, it says no issues or concerns reported. It couldn't be anything further from the truth. That in fact he does suffer from the ADHD. He does suffer from the depression. I don't want to make Dr. Wint's forensic report a part of the pre-sentence investigation report because that follows him, but I would just indicate here that at least indicating the ADHD and the depression should be listed there.
Any objection?
Well, I mean, I don't know that I have an objection, but I'm looking at what the defendant filled out, and he indicated that he didn't have any of those, that it was all non-applicable.
Judge,
So when the defendant was asked if he had any mental health problems, he said no.
Okay,
So,
and certainly, there's no question it's ADHD, right?
well, there is a question about that. I mean, while Dr. Wentz testified that he had untreated ADHD, there's no diagnosis from a medical doctor that the defendant suffers from ADHD.
There was earlier in his life and during
Correct.
the course of his schools. I'm going to add ADHD and depression.
and depression. Thank you. On page, going over to the, there's another page 1 under criminal history. It says age of first arrest. It says 17, but I asked that that be changed to 18 because this case, he had just turned 18 when he was arrested.
He was ticketed on the retail fraud.
He was never arrested, Judge.
Ticketed, right? So he was, this is his first arrest?
Yes.
Okay, 18. Right.
Does the court want me to, that's all as far as the body of the pre-sentence investigation report. Those are the corrections. I have nothing else other than what I've placed on the record to add.
Okay.
I do have a couple of objections to the pre-sentence report. I mean, strike that, to the advisory guideline scoring.
Okay.
Do you want me to go into that right now?
Sure.
Judge, under the child abuse first degree, I would object to OV10, which is scored at 10 for exploitation of a victim. I don't think that that fits necessarily the definition of, just because this was, and we acknowledge that this was a baby, that in fact, I think the exploitation is one typically scored when someone goes and preys on someone younger or something of that nature. I don't think that these facts lend themselves to an exploitation. Unfortunately, it did result in the child's eventual death, but I don't think that it falls under that category. I would ask that the court strike OV10 and score that at 0.
I have no problem with that.
Okay, that's OV10, so you want OV10. You don't have any objection to OV10 being scored at 0?
That's correct.
All right.
Judge, that would change, or that would change the OV total to 25.
Okay.
And I don't have my guideline book in front of me. I don't know if that changes the grid, Mr.
I do, Your Honor. I don't believe it changes the grid.
Would still fall under a C2, which is a 51 to 85, but as long as that's changed.
Okay. 51 to 85.
As it relates to the advisory guideline scoring on the second-degree murder, I would take issue with OV19, which is presently scored at 10, which is an interfering with administration of justice. Again, I don't feel that these facts lend themselves to a scoring of 10 points on that. Even if the prosecution would argue that there were different stories, he was always in custody, he was never going anywhere, and he clearly didn't cause anything additional by way of anything that the police had to do, because they had already, for lack of a better word, duped him into believing that he was being arrested for the retail fraud misdemeanor. He was already in custody, never left custody, was never allowed to drive with his family back to the police department, even if he decided that he was going to talk to them. So I don't see how that can be scored at 10 points. So I'd ask that that be stricken and scored at 0.
Your Honor, I believe probation properly scored OV19 at 10 points. I believe the case law holds that if a suspect lies to the police during the course of their investigation, that is considered interfering with justice under OV19. And specifically in this case, the defendant made statements about the cause of Aiden's injuries, and he knowingly lied to the police and described the injuries as occurring on the stairwell of the condo on the railing. Based on those statements, the police, along with a crime scene unit, did develop a diagram and measurements and pursued an investigation as it related to the handrail. Those were admittedly by the defendant, lies that he made to the police because he didn't want to go to jail. And those are his words, Your Honor. So I do think it's properly scored at 10 points.
It seems like OV10 would be more appropriate in the event that Mr. Honer said, yeah, I saw the daycare provider dropping him, or, it's kind of like sending the police on a police chase. So I think that he gave a watered-down version of how the injuries occurred initially. I don't think that he interfered with the administration of justice on his OV-19 at 0.
Thank you. With that change, Judge, the guideline range would be, the OV score would be 75, and I don't believe that that changes the... Unfortunately, it does not change the advisory guideline range, which would still be at a C2, which would still be the 180 to 300, but it would lower the OV total. With that being said, Judge, I have no other guideline challenges, and as it relates to the pre-sentence investigation report, I have nothing else further to comment about that. Just now I have allocution, but I would like for the prosecution to speak now.
Prosecutor?
Yes, Your Honor. As the court knows, this case resolved by way of a plea agreement as well as a sentence agreement. I think the Department of Corrections recommendation reflects what that agreement was, and I would ask the court to follow the recommendation. The court's familiar with this case, and I think everyone would agree that this is a very tragic case, and that an innocent 7-month-old baby lost his lives at the one person that was supposed to protect him and keep him safe. I think that the recommendation is fair, and I think it serves the interests of justice, and I would ask the court to follow it.
Judge, I can admittedly say this is probably one of the hardest, most difficult cases that I've tried in all of my years of practice. It's one of those situations, Judge, where going in, you know that it's my client was originally charged with first-degree murder and the first-degree child abuse. And getting to know this, at that time, 18-year-old, and I'm going to call him a child, because essentially that's exactly what he was. Little did I know, in speaking with Mr. Honer some over 650 days ago, when I first met him and was appointed to represent him, that the information that I would get from extensive, I mean very extensive work on his case, that in fact, although he was 18 years of age chronologically, that pretty much Mr. Honer from day one in his life was kind of doomed from the start. And the reason that I say this, and I know, Judge, that there is a plea agreement and a sentencing agreement, but I think that the record needs to be clear as to what happened here and what went on. I realize that this, and I would agree with the prosecution, that in fact this is very tragic. And this was a situation that a 7-month-old baby ultimately lost his life. But from the beginning, as I indicated, Mr. Honer was pretty much doomed. He's born into relative poverty. He had mental health issues that were throughout his life. He was in special education. I know this because part of my 12-plus witnesses, 2 of them were school teachers of his that sought me out and gave me information regarding Mr. Honer, not even understanding how this could have possibly have happened, because they knew this kid and they were at school. And I even talked with one of the administrators who was also on my witness list from the Pontiac School District that did the IEPs, and so she was quite familiar with Mr. Honer as well and could not fathom how this could actually happen to this kid. Judge, it's one of those situations where on the day of trial the court knew that I'm always extremely prepared for my clients, be it a insignificant case or something that doesn't have as much by way of penalty, to the ones that are like Mr. Honer's, that are very, 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 very important and very, very, penalty in his case was life without parole. I was prepared for a trial, and I had made a record of that. My client knew that. My relationship with Mr. Honer over these 650 plus days is excellent. He knew I was prepared. I kept him informed every step of the way with all of the, despite the fact that I'm appointed, despite the fact that there were experts that had to be paid by the court, by the county. They were all on board. Dr. Honer, Dr. Wendt, who the court saw testify, did reports, did things over and above what even a person who was paid by a retained client did. And Judge, we were prepared. We were prepared to go forward with his defense.
I know you were prepared. I know that.
I'm saying all this to say, so Mr. Honer can hear me say this in open court, is that in fact, on the day of trial, I had to, which was the right thing to do, put aside my feelings, and I'll be honest, I think that he had a very viable case to go to trial. But Mr. Honer told me on the morning of trial that in fact he could not take that chance of a possible guilty verdict by a jury and spend the rest of his young life in prison with no hope of parole.
It would have been a big risk,
And it was a gut-wrenching decision. But I respected what Mr. Honer said, and as the court knows, it did end up in a plea of no contest. Judge, Mr. Honer is a good person, despite what the prosecution may think. Again, I think that he is and will be, to a certain extent, a victim himself. If he had gone to trial, and I would have gotten perhaps a conviction on a second-degree murder, it would have given me the opportunity to present by way of mitigating circumstances, because the recommendation is within the advisory guidelines. The plea agreement is within the advisory guidelines, but what he agreed to, the 25 years that the prosecution would not budge on, instead of saying they would agree to reducing the charge and letting the court decide what the sentence would be, there would have been no agreement but for the fact that Mr. Honer agreed to the 25 years, which is at the top of the advisory guideline range. Had he gone to trial, gotten a second-degree murder, I'm sure that the mitigating circumstances, the fact that no contest, it was never contested that in fact his IQ was approximately between 57 and 60. Dr. Wendt testified that if you lined up 100 people, 99 people would be smarter than he is, and he stands at the very end. All of those circumstances, Judge, aside from his untreated severe ADHD, those would have been mitigating factors that I cannot argue now because he agreed to the 25-year minimum as a part of a plea agreement and a sentencing agreement. And so unfortunately, for the record, the court cannot take that into consideration, but that would have been something clearly that the court could have done. This isn't a situation, Judge, where he woke up that morning and said, I think I'm going to kill my child. It was nothing even close to that. And that's what troubles me so, and I feel so constricted and conflicted with the fact that the court won't be able to consider that. And that's one of those situations. So
You're well aware, and so is Mr. Holman, that we could have been here sentencing him in first degree.
And Judge, I do. And that, making that full circle, and that's why I said I absolutely respected the fact that he made his decision and took control of his life, and to his credit, it couldn't have been an easy decision for him as well. but he did. And it's just one of those situations, Judge, that I just really felt compelled that the record should be clear there, because even if he had gone to trial, and worst case scenario, there was or could have been a conviction, there were other appellate issues that could have been addressed as well.
Sure.
That now he will not be able to address those issues.
Sure.
But I know that the court is bound by the agreement, but this isn't one of those situations where you've got this very bad person. Something very bad happened.
He has no history. He has never been arrested for a single crime, and there's no history of violence with regard to him. Unlike a lot of defendants who are here, we have a substantial school history with social history with regard to Mr. Homer, and there's no history of criminal behavior or violence whatsoever.
No, and this was one of those situations where a child, and talking with his teachers who said that they had classes or attempted to have classes where they would tell them about children or caring for children, they were all in agreement that he was the last person that should have had a child and taking care of a child. And as it related to the administrator that also from the Pontiac School District that was on the witness list that was going to testify had indicated, again, none of that behavior was exhibited, any of that aggressive behavior, anything like that. And they were very, very troubled to know that. So, Judge, I'm really, other than what I've said, at a loss of words. It's one of those situations where hopefully if something like this comes up in the future, that the prosecutor's office would look at things a little bit more humanely and look at not only the alleged victim or the victim in the case, but how it affects not only the victim, but the defendant and their disabilities, and how that comes into play. Because that's what comes into play when guidelines or advisory guidelines are used when it comes to sentencing. So, Judge, again, I'm not standing here trying to undo what's been done by way of a sentence. I'm not saying, because these are my words, these are not my client's words. My client didn't ask me to say this, but I think it's necessary that it be placed on the record. He is not, even after the plea was taken, he never said that he wanted to withdraw his plea. He's been at peace with it. I've seen him several times since the taking of the plea. I saw him this weekend. I saw him as late as this morning, and he's at peace with it. But I just thought that the record should be clear. This is not a situation where you've got some monster that did this to this unfortunate child. And he'll have to live with what has happened, and he's just been remorseful from the beginning. Thank you.
Mr. Homer, I think that you know that you had a very strong advocate in Miss Gracie, and I don't think if you had $1 million you could have gotten better representation. Would you agree with that?
Yes.
She definitely went to bat for you every step of the way. So what do you want to say about sentencing?
I just want to say, sorry that I had to go away from my family. And I was like, what I did, you know, I can take back what happened. But other than that, just hope that this time bettered me, made me a better person. I hope that my family and everybody be okay. Thank you for fighting for my life. That's pretty much it.
Well, I guess I would say to you that this does appear to be a character. You don't have a history of violence at all. There's no criminal conviction. And I'm sad that you're standing there too, because he had skull fractures and a brain bleed. He was neurologically devastated. He had blunt force trauma to both sides of his head, and there were signs. And I think when I read this, the neurosurgeon specialist was prepared to testify that there were old injuries to this child So that would mean that this is not the first time the child was assaulted. And obviously, it's unclear whether or not you had assaulted your son prior to that day or not. But when I read that, I'm convinced that you made the right decision in pursuing second-degree murder charges, because I'm sure in conjunction with the abuse of the child and the fact that this child had prior injuries and had been in pain previously and had a brain bleed previously, I'm quite certain that the jury could potentially convicted you of first-degree murder, and that I would then be sentencing you to life without parole. That didn't happen. I think that you made an intelligent choice to plead to a second-degree murder, so that you'll have the opportunity for rehabilitation and to be released and have some life left to you. But there were profound injuries to Aiden, again, on both sides of his head and prior brain bleeds. And then the mother has indicated that she did see you shaking Aiden violently back and forth, with his head was snapping back and forth. And, that's what she says. Only you and her know, only the two of you know for sure what happened to this baby. I guess I would adopt the words of the prosecutor. You were supposed to protect your son, and instead you killed him. And because of that, with regard to the second degree, count to child abuse in the first degree, it's a sense of this court that you served 7 to 80 years in the Michigan Department of Corrections with 656 days credit. And with regard to count 3, the murder 2 conviction, 25 to 80 years in the Michigan Department of Corrections with 656 days. There's a crime victims, that's the credit, 656. The crime victims' rights fee of $130, court cost $500, state cost $136, attorney fees to be determined. DNA, you must have had DNA testing. DNA cost is $60, and you must have no contact with Ariana Avery. May God forgive you. Could you give him his appellate rights?
Yes.
Thank you.
So John is tendering his appellate rights to Member Arnold.
Thank you.
All right.
Everybody should remain seated. Everybody should remain seated.